All right, welcome into the AFC Press Newsroom. I'm Brian Jonas, National Press Secretary, American Federation for Children. I've got Shaka Mitchell, Senior Fellow for AFC. Shaka, it's Tuesday, February the 10th as we sit today. So happy Tuesday to you.
Hey, Brian, good to see you.
Yeah, good to see you. So look, a headline that caught our attention late last week and wanted to talk about it a little bit this week, unpack it a little bit as we've seen some news develop around this is Supreme Court upholds private education tax credit. That's from the Idaho Ed News. And so we've been watching this. We've talked about it a lot before, but here's what ultimately plays out all the way to the state Supreme Court level in a 5-0 decision. Challengers failed to essentially show how the new tax credit in Idaho violated the state constitution, saying that the legislature doesn't fund public education. So just catch us up to speed. I mean, look, it is obviously a great headline for our movement, for parents and families and kids across Idaho, but what does this mean? Help us understand it a little bit.
Yeah, so this is a really important case, important for Idaho, but also important for what it means nationally, because this is just more evidence of a national trend that we see when it comes to state Supreme Courts and even the U.S. Supreme Court. So maybe we talk about that a little bit later. But in the context of Idaho, what this means, first and most fundamentally, is that thousands of kids are going to get to participate in the Idaho, school choice tax credit program. All right, so that's really important. It means that those families are going to get to take those dollars. They're going to get to use them as they see fit to make sure that the education meets the needs of their kids. And so fundamentally, that's the most important thing. What this also means is that the Idaho State Supreme Court upheld this idea that the legislature is able to go above and beyond just the common school system, the common public school system. It's able to go above and beyond that to do more for kids, and that is fully constitutional.
Interesting. Now, the timing also critically important, right? Because this is a new program just passed a year ago, signed into law, which means now families are going through the process of ideally applying and being awarded scholarships and being able to benefit from this. So this timing also really critical.
Yeah, that's right. So the timing is critical. And by the way, that's what opponents of these programs do. They wait until the timing is critical. They wait until it's going to be really disruptive for families, right? When families are applying and they're making decisions about the coming school year, and then they file suit, these things get tied up in litigation that ends up being really costly to taxpayers and ultimately doesn't go anywhere, as we saw here. I mean, this is a unanimous decision by the Idaho Supreme Court that upholds the rights of parents to use public dollars as they see fit for their kids.
I want to ask you more about the tactics, but I also, just for the education of our audience who's either watching or listening to this, that 5-0 ruling, should we read into that? What does that tell you? I mean, unanimous decision on a court this day and age, rare, is that unique? What do you think?
Yeah, I can't say because I'm not a scholar in all of Idaho jurisprudence as to whether or not how rare that is. But I'll say this: when you get a unanimous decision, it is a really resounding thing, right? And specifically, this is interpreting the Idaho state constitution. So, at the risk of boring you, let me just give you a little bit of what the Idaho Constitution says.
Yeah, helpful.
So Article 9, Section 1 of the state constitution says that the legislature shall have a duty to establish and maintain a general, uniform, and thorough system of public, free, common schools.
Okay.
That language is pretty typical of many, many states, right? Okay. Legislatures have to provide for common schools. What the Idaho Education Association, the teachers union, and others who filed this lawsuit believed was that language in the state constitution sort of functioned as a ceiling, that it was both mandatory and
that's it, right? But no, it's more of a starting point, right?
It's more of a starting point. That's exactly right. So this would be a little bit like if I said to you, Brian, you have a duty to provide your kids with dinner every day, and you said, okay, cool, and then you said, in the middle of the day, you said, oh, hey, guess what, kids? I've got a snack for you. And I said, no snacks, because we said that you had to provide dinner. And of course, that would be absurd, right? Like you would say, you can do both of these things. And that's exactly what the Idaho state legislature is doing. They're saying, yes, we're going to provide public common schools, and we're going to provide this other vehicle for families who say, hey, that system unfortunately doesn't work for us.
All right. So I hear you, and that all sounds like candidly real common sense, and it makes a lot of sense, and it's pretty clear.
Yeah.
And also caveat, the Idaho legislature has not stopped funding public education. So it's not like, so I guess my question is, I think I know the answer. We've seen this tactic play out in states across the country where we make the argument that the big schooling unions, the big education loyalists really use these more as a delay and disrupt than
That's right.
actually a mechanism, because the argument you just made makes it very clear that they were not in violation of the state constitution. And, and you have to think that everybody can see that.
You'd like to think that this is plainly obvious, but it's not plainly obvious. And listen, hats off to the Idaho Supreme Court, because they also ruled, by the way, that the plaintiffs in this case didn't even have standing. Okay, so weren't even able to bring this case. But the court thought that this was such an important issue that they said, you know what, we're going to rule on this anyway, because they take this very seriously, as we all should. We should care about the education of all of our kids. But I think what we're seeing more and more, and that's in Idaho, currently in Wyoming, there's actually oral arguments happening right now. There's an ongoing lawsuit in Ohio, Tennessee, probably some other places around the country. Yep. These really are delay tactics. And when we talk about lawfare, you know, people waging lawfare, that's really what they're doing. They're often just coming to the courts with fabricated problems, right, so that they can confuse and delay parents' ability to provide the best education for their kids.
Yeah, well said. And I even noticed, and really, I mean, there's a lot of folks to thank, specifically in Idaho, Tax Commission, the Attorney General's office, the legislature, in-state partners who helped see this through. But I also noticed, the court also granted attorney fees back to the Idaho Tax Commission, which was defended by the Attorney General. So again, you can see where it appeared to be pretty clear on that. Look, we're not but 11 years since my home state of North Carolina, our scholarship program, our opportunity scholarship program, deemed constitutional by the state Supreme Court. So we've seen these play out. We've seen them reach sort of the highest of the state court levels. Yeah. But we've also seen this reach the highest court in the land. You mentioned that earlier. So tell me a little bit more about, where sometimes these have even been elevated all the way up to the Supreme Court of the United States.
Yeah, that's right. That's exactly right. So the United States Supreme Court has actually ruled on school choice programs a number of times, going all the way back to Zellman v. Simmons Harris. This is a 2001 case that came out of Ohio. But just as recently as a few years ago, in a case called Carson v. Macon, it's out of the state of Maine. And the U.S. Supreme Court has consistently said that when parents are able to take state dollars, public dollars, and use those for the benefit of their child's education, that is perfectly constitutional. One of the things that we saw in the Idaho case, but it comes up in many states, people try to say, well, this is money benefiting private entities. And the Idaho court said something really important. They said that incidental benefits to private entities are constitutional, right? Incidental meaning when money goes to a family and the family uses that for tuition, say at a private school, or uses it to buy books from a private, shop from Amazon or what have you, some curriculum. That is just an incidental benefit, because the primary benefit is to the student.
Yeah, that's right, to the kid.
Common sense. And so you said, hey, this actually sounds really reasonable and sounds like common sense. Well, you're in good company, because the U.S. Supreme Court also thinks this is pretty reasonable and commonsensical. And, time and time again, we've just seen the court side with parents.
Yep. Well said. Well, look, I just want to take a few minutes and really help us digest this, understand what this means. It's not always a precursor for what could continue to happen across the country, but at least shows sort of another precedent and another data point in this conversation. Shaka's available. He can always talk more about this. We have a lot of resources available at the American Federation for Children. Shaka, before we go, remind everybody where they can find you. I know you're producing a lot of content, writing a lot on your Substack, so tell us a little bit more about that.
Yeah, absolutely. Thank you. Well, you can always keep up with what I'm doing on X at Shaka Mitchell. You can find it at Shaka's Substack, and of course on our website, federationforchildren.org.
Amazing. All right. Great update. Appreciate you telling us more about it.
All right. Thanks, Brian. Take care.